Good morning, everyone. The open meeting of the Federal Election Commission for Thursday, November 17, 2016 will now come to order. First item on the agenda, item number 1, is Draft Advisory Opinion 2016-16, submitted by Gary Johnson, 2012. Set forth in current agenda document is 16-61-A. We have Jessica Zelenkoff and Robert Knopp from the Office of General Counsel to give a presentation. And, yes, I believe we, before we launch in, we have some late submitted documents. Mr. Vice Chairman.
Mr. Chairman, I move to suspend the rules on the timely submission of agenda documents in order to consider the late submission of the following documents. Agenda document 1657A1, AO2016-20, revised draft A, and agenda document 1657B, which is AO216-20, draft B.
Any discussion on that motion? If none, all those in favor indicate by saying aye. Aye. Any opposed? Madam Secretary, that motion carries by a vote of 6-0. We'll now turn to Ms. Zelenkoff to give a presentation on the Gary Johnson AO request.
Thank you, Chair Peterson. Good morning, Commissioners. Agenda document 16-61A presents a draft advisory opinion in response to a request by Gary Johnson, 2012, a publicly funded presidential campaign committee. After an audit, the Commission determined that Governor Johnson and the committee must repay approximately $300,000 to the United States Treasury. The Commission also made 2 audit findings for which the committee may incur civil penalties. The committee asked several questions regarding the sources and amounts of funds it may raise and use to pay these debts. The draft concludes that the committee may accept funds to pay its obligations from individuals who are currently allowed to contribute to candidates, but who were prohibited sources, either federal contractors or foreign nationals, in 2012. The committee may accept contributions for Treasury repayment subject to source and amount limitations, and may accept donations for civil penalty payments without regard to amount limitations. The draft also concludes that a third party's payment directly to the Treasury or to the Commission to satisfy the committee's obligations is subject to the same source and amount limitations and the same reporting requirements as payments received by the committee directly. The Commission received no comments on the request or the draft, and we're available to answer any questions you may have.
Thank you for that presentation. Do we have any questions of council or any discussion on this advisory opinion request? Hearing none, do we have a motion? Mr. Vice Chairman.
Mr. Chairman, I move agenda document number 1661A, draft A.
Any discussion on that motion? If none, all those in favor indicate by saying aye. Aye.
Aye.
Any opposed? Madam Secretary, that motion carries by a vote of 6-0. Thank you, Ms. Zelenkoff. We'll move to item 2 on the agenda, Draft Advisory Opinion 2016-17, submitted by the Libertarian Party of Michigan Executive Committee. We have Joe Wenzinger from the Office of General Counsel and Bob Knopp here to give a presentation. And good morning, and when you're ready, please begin.
Thank you, Chairman Peterson. Good morning, Commissioners. Agenda document 1659A is a draft response to an advisory opinion request submitted by the Libertarian Party of Michigan Executive Committee, Incorporated. The requester asks whether, under the Act and Commission regulations, it qualifies as a state party committee of the Libertarian National Party. The draft concludes that the requester does qualify as a state party committee of the National Party because, in addition to placing a federal candidate on a ballot and being recognized as an affiliate by the National Committee, the State Committee provided articles of incorporation and bylaws showing that it is responsible for activities commensurate with the day-to-day functions of a political party at the state level. We did not receive any comments on the request or on the draft. I'm happy to answer any questions you might have.
Thank you for that presentation. Are there any questions of council or any discussion among commissioners? Hearing none, do we have a motion, Mr. Vice Chairman?
Pardon me. I'm still chewing on this lifesavers. I appreciate it. I hereby move approval of agenda document number 1659A, draft A.
Any discussion on that motion? None. All those in favor indicate by saying aye. Aye.
Aye.
Aye.
Any opposed? Madam Secretary, that motion carries by a vote of 6-0. Mr. Wenzinger, I know you're on deck for item number 3, which is Draft Advisory Opinion 2016-18, submitted by the Ohio Green Party, and where you're considering agenda document number 16-60-A.
Thank you. Agenda document 16-60A is a draft response to an advisory opinion request submitted by the Ohio Green Party. The requester asks whether, under the Act of Commission regulations, it qualifies as a state party committee of the National Green Party. The draft concludes that the requester does qualify as a state party committee of the National Party because, in addition to placing a federal candidate on a ballot and being recognized as an affiliate by the National Committee, the state committee provided a constitution and bylaws showing that it is responsible for activities commensurate with the day-to-day functions of a political party at the state level. We did not receive any comments or requests on the request or on the draft, and I'm happy to answer any questions you might have.
Thank you for that presentation. Are there any questions of council or any discussion on this draft? Hearing none, Mr. Vice Chairman, do we have a motion?
Yes, we do. I move to approve agenda document 16-60A.
Any discussion on the motion? If none, all those in favor indicate by saying aye.
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 Any opposed? Madam Secretary, that motion carries by a vote of 6-0. Thank you, Mr. Wenzinger. I think you now may qualify as a veteran AO counsel, so gloves are off in the future. We'll turn now to item 4 on our agenda, which is Draft Advisory Opinion 2016-19, submitted by the Libertarian Party of Colorado. We have Joanna Wallstreicher and Bob Knopp here to give a presentation.
Thank you, Chairman Peterson. Good morning, Commissioners. Agenda document 16-56-A is a draft response to an advisory opinion request submitted by the Libertarian Party of Colorado. The requester asks whether, under the Act and Commission regulations, it qualifies as the state committee of a national political party. The draft concludes that the requester is a state committee of a national political party because the Libertarian National Party is a political party. The requester is part of the official structure of the Libertarian National Party, and the requester is responsible for the day-to-day operation of the national party at the state level. We did not receive any comments on the request or on the draft, and I'm happy to answer any questions.
Thank you for that presentation. Are there any questions of council or any discussion on this request? Hearing none, Mr. Vice Chairman, do we have a motion?
Yes, we do. Excuse me. I move to approve agenda document 16-56A, draft A.
Any discussion on that motion? Hearing none, all those in favor indicate by saying aye.
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 Any opposed? Madam Secretary, that motion carries by a vote of 6-0. Thank you, Mr. Wallstreicher. We'll now turn to item 5 on our agenda, which is Draft Advisory Opinion 2016-20, submitted by Christoph Mlinarczyk? How?
I believe it's Milinarczyk.
Milinarczyk, okay. We have Esther Jory and Nevin Stepanovic from the Office of General Counsel give a presentation. So good morning to you, and when you're ready, please begin.
Thank you, Chairman Peterson, and good morning, Commissioners. Agenda documents 16-57-A, 16-57-A1, and 16-57-B are draft advisory opinions responding to a request from Christoph Milinarczyk. The requester is the sole member of Christoph LLC, a single-member Virginia LLC that has not elected to be treated as a corporation under the Internal Revenue Code. Through Christoph LLC, Mr. Milinarczyk provides advice and consulting in government contracts. Christoph LLC is currently negotiating a contract with the federal government. Mr. Milinarczyk asks whether he, as the sole member of Christoph LLC, may make contributions from his personal funds. Drafts A and A-1 conclude that Mr. Milinarczyk may not make contributions from his personal funds because, under Commission regulations, a single-member LLC that has not elected to be treated as a corporation for federal income tax purposes is disregarded as an entity separate from its single member. Draft B concludes that Mr. Milinarczyk may make contributions from his personal funds because he and the LLC are separate entities under state law, and thus Mr. Milinarczyk is a member of an organization that is a federal contractor. We received one comment on the request and one comment on the draft. Thank you, and I would be happy to address any questions that you may have.
Thank you, Ms. Jory, for that presentation. Do we have any questions of council or any discussion among commissioners? I'll just state at the outset, and I mentioned this to the Vice Chairman, that I'm not going to be prepared to vote on this one today. This matter, and I talked to Mr. Nodi also about what the time implications are. From what I understand, the 60 days run on November 28th, and our next open meeting is on December 1st. So if we were to consider it or vote on it in a future meeting, we would need a small extension of 3 days. If that's not granted, we'd obviously have to resolve this on tally between now and then. As I was going through this one proved to be a little more going on here than when I originally looked at it. It maybe seemed a little more straightforward. Not being a tax lawyer, not being expert in the ways of LLCs and what the implications are of LLCs being taxed as corporations versus LLCs being taxed as partnerships or single-member LLCs that opt not to be taxed as corporations, becoming disregarded entities, which is the case here. It's in a little bit, we have, with respect to the federal contractor contribution ban, we have two different provisions that are relevant to this discussion. And first is in Section 115.5, which says that individuals or sole proprietors who are federal contractors are prohibited from making contributions or expenditures. But then in Section 115.6, it says that stockholders, officers, or employees of corporations or employees or members of an unincorporated association, cooperative, membership organization, labor organization, or other group or organization, which is a federal contractor, may make contributions or expenditures. So this LLC, this disregarded entity, is a little bit of an odd creature. On the one hand, for tax purposes, all of the assets and all the assets are owned by the single member, and therefore would appear to fall into the ban in 115.5. However, from a liability perspective, it is considered a separate entity, and so a single member. There's the argument that it could be considered an organization, and that the single member would be able to avail themselves of making a contribution in 115.6. This is like I said, a pretty complicated issue. This issue even was addressed to some extent in the Wagner case on what LLCs may or may not be able to do with respect to the federal contractor ban. And we have received at least one comment on this, but I'm hopeful, and to anyone who may be listening and has some expertise or thoughts or ideas on this, some additional comment, if any, were to flow in here, I think would be helpful, because I think this is a bit of an unusual request, and it's one that we've never had to deal head on. So I'm going to not be prepared to vote on it today, and hopefully we can get an extension from Mr. Malarnachek. But if we can't, then we'll figure out some way that we can resolve this by the 28th, when the 60-day period would otherwise run. Commissioner Weintraub.
Thank you, Mr. Chairman. Well, I was prepared to vote. I didn't realize we weren't going to vote today. I was prepared to vote for the revised draft A, which is substantially similar to the original draft A, but some changes were made in response to the comment of the requester, who said that certain facts were not quite right. And I think that I disagree that this is, really something brand new. I think it is largely substantially similar to Advisory Opinion 2009-02, True Patriot Network. Issues related to government contractors who operate as through LLCs or I don't want to say small government contractors, but individuals similar to this, I think were raised in the Wagner case. And they had some very sympathetic plaintiffs for the argument that these kind of folks shouldn't be covered by the federal contractor ban in the same way as big corporations are. And yet the court upheld the federal contractor ban in the Wagner case, and none of those arguments seem to work. So I think that I looked at draft B, which tries to separate out this person and what he does with his personal funds from the LLC, which is really just an alter ego for that same person. And it strikes me that it's elevating form over substance. you know, if you, if you want to vote for that, I guess you can, but I don't really think it holds up. There's a comment that we have received on the substance of all of this. I take it you're sort of asking for somebody on the other side of the issue to come in and give you some backup, and maybe somebody will do that. There are certainly folks out there who are always happy to come up with a rationale for not enforcing the campaign finance laws, but I don't think this is a tough one personally.
I'll just make just a couple responses. That's not what I'm asking for, is for backup. I'm not, I was supportive of draft B going out. Hope to see, what's that?
B or A?
Draft B.
Going out.
Going,
Sorry.
making it blue,
Got it,
public,
got it, sorry.
to get some feedback. That it shouldn't be read as that's my final position at all. But I am interested, considering that I think that this is a little bit more of a new situation. I think True Patriot Network, in that particular case, the issue was if the LLC itself makes a contribution. In this case, the individual wants to make a contribution out of personal funds, and what are the implications of the fact that he's a government contractor? Maybe I take it you would say that that's a distinction without a difference. To me, I think it may actually be relevant. It may not. True Patriot Network may govern in this particular case, but I just wanted to have a little bit more time to kind of chew on that thought. Commissioner Goodman.
Commissioner Weintraub, you say that this is not something brand new, and yet in the Wagner case, it was the argument of the plaintiffs there that the contractor ban was unconstitutional because it was under-inclusive, because individuals could set up entities such as LLCs, and that was a constitutional flaw in the ban. And this commission and its Office of General Counsel conceded the argument that individuals could set up corporate entities and LLCs and maintain their First Amendment right to give. And the court even noted that concession by this agency in the Wagner court. Here's what the en banc court said. Although the FEC's briefs accepted the plaintiff's description of the regulatory treatment of individuals who establish LLCs, the agency later submitted a post-argument letter clarifying that the commission itself, quote, has not addressed the application of FECA's contractor contribution prohibition to contributions made by an individual who is the sole member of an LLC that is a federal contractor. Now, we all recall the circumstances under which our Office of General Counsel was directed to send that letter, and there was also oral argument in which our Office of General Counsel conceded that individuals could set up these entities and maintain their First Amendment rights nonetheless to give, because there is a separateness. By law, this LLC is not the alter ego for debts, for contracts, for a whole host of purposes. This entity is not the alter ego. That's why they have the LLC construct. So this is a case of first impression, and I believe it would behoove us to take a little bit more time to get this right, and not to blithely conclude that this has been previously decided by this commission.
Mr. Node, I would just turn to you and just would ask you if there's any problems with you being able to reach out to this requester to find out if we could get that extra time, and if we could figure that out sooner rather than later. That would obviously impact the how we proceed from here, whether or not we need to do this on tally, or whether we might be able to resolve this at the next December 1st open meeting.
We'll reach out to him right away.
Okay. Is there any other discussion on this matter? If none, we will hold this either until the next meeting or resolve this by tally by the November 28th deadline. Thank you, Ms. Jordan. Mr. Spanovic. The draft, as the agenda indicates, the draft advisory opinion 2016-21, Great America PAC, that is going to be held until the next meeting. That takes us to agenda item number 7, which is proposed amendments to Directive 52, set forth in agenda document number 16-55-A. Sure. We will hold consideration of the proposed amendments to Directive 52 until the December 1st meeting as well, which brings us to item number 8 on our agenda, which is proposed final audit report on the Utah Republican Party. We have a whole host from the Audit Division and from Office General Counsel, Ms. Smith, Ms. Morcom, to give a presentation. Mr. Holloway, Foreman, Intermeister. I will turn it over to whomever was going to reach for the microphone first. So,
good morning, Commissioners. Before you is the proposed final audit report on the Utah Republican Party. It consists of 6 findings as follows: receipt of prohibited contributions, receipt of contributions that exceed limits, misstatement of financial activity, record keeping for employees, reporting of debts and obligations, and apparent excessive contributions staff advance. We are available to answer any questions you may have. Thank you.
thank you for that presentation. Do we have any questions or discussion? I believe, anyone can correct me if I'm wrong, but I believe that the only issue that is a sticking point in this is finding number 4 regarding record keeping, and that I think that there's unanimity as to findings 1 through 3 and 5 and 6, and that if we had a motion as to those, we would, I think, have unanimity. And then if there's a follow-up motion on the finding as is on finding 4, and then if there's not a consensus as to that, then I think there would be a third motion, which I think is consistent with some of the ways we've handled this record-keeping issue in the past. Commissioner Weintraub?
Thank you, Mr. Chairman. I didn't realize there was no information provided on what the objection was about. There were 5 votes for this and 1 objection, and we found out last night what the issue was. You know, I looked at it and I sort of thought that might be the issue, but we didn't confirm it until late in the day yesterday. And I think we find ourselves in a procedural posture that we have not found ourselves in before on an audit report, where we get an audit division recommendation memorandum from our staff, and it presents us with certain legal conclusions. It says we recommend that the commission approve the following conclusions, the following findings, and that passed unanimously. That was approved. So the commission has already approved these legal conclusions, and usually that's the point where the objection comes in. It's like, no, we don't approve those conclusions, so we're going to, we need to have the final audit report prepared differently. This is the first time that the audit division recommendation on legal findings has been approved, and then at this last stage of approving the final audit report, the commission has balked and said, no, we wanted basically a do-over on the conclusions that we approved in the ADRM. I don't think that's ever happened before. And I'm not, don't misunderstand me, I'm not saying that I'm necessarily going to object, but I would like a little bit more time to think about procedurally how to go about doing this. Because this is, I mean, because we checked, and this has actually never happened before.
Yes, Commissioner Goodman.
I'm not sure what posture was before us in Audit Division Recommendation Memorandum of the Kentucky State Democratic Central Executive Committee. But there I have a vote certification. We thought we were in line with the procedure taken there. So there, the certification, March 10, 2015, shows that the commission failed by a vote of 3-3 to approve the recommendation for the record keeping for employees finding as set forth in agenda document number 1512-A, subject to an amendment to include the $257,000 paid to contract workers. And then 2, decided by a vote of 6-0 to approve the recommendation for the record keeping as to a different dollar amount and to direct the audit division to include now how is that different than
That was
where
at
we
the
are?
ADRM stage. That was at a previous.
So you're saying I
point.
missed the boat?
Well, I'm saying that, well, yeah, but, and maybe it's fixable, but I just want a little bit more time to think about procedurally how to do that, because that is the juncture at the ADRM. That's where you're right, substantively, we have addressed this issue before. But that's where we usually address it, is at that point in the process. And once the conclusions have been, the legal findings have been approved in the ADRM, I don't think we have ever had an occasion to go back and redo them. So I just want a little bit more time to think about that procedurally.
Okay. When we can pick this up then at the next meeting and figure out, and we can be in consultation with the Office of General Counsel, with Mr. Calvert, to figure out what's the best way to address this. I think you may be right. I think this may be the first time that we've done it at this stage. So why don't we take the time that we have between now and the next meeting and figure out what's the best procedural mechanism to go forward to ensure that.
I don't know, maybe we need to reconsider the ADRM, but I'm not sure. It just never happened.
I know that I've been accused of objecting at the interim stage too often, to the consternation of several commissioners.
No, but this is.
No, I'm just saying,
interim.
I have been accused of objecting too soon in this audit process here. I may have come in too late. So I will preserve my objections at the earliest possible stage henceforth.
Well, just to be clear, because we have this, I never liked this convoluted audit process with its multiple stages, but, it took us a year to negotiate this. This was before you got here, Commissioner Goodman, but it took a year to negotiate Directive 70, and there's an interim audit report, and then subsequent to and that's the part where we usually kind of just let the process play out, because it gives the the committee being audited an opportunity still to respond and for us to consider their responses. And then there's an audit division recommendation, which presents us with proposed legal conclusions and a draft report. I continually get confused as to whether that's technically called the draft report or the proposed report. And then after we approve those legal findings, the staff prepares whether it's draft or the proposed at that point.
Because
TFAR.
Because the interim report, then the draft audit report, then the audit report,
and
the final.
And then the final, right. It's a like I said, not it's the process a little bit too convoluted for my taste, but it's that ADRM where commissioners usually weigh in with whatever they want to, if they want to object to any of the final legal conclusions. So like I said, I just think that procedurally, we are not in a substantively new place, we're just in a procedurally new.
Mr. Chair, if
Commissioner Goodman.
it proves necessary, and if that ADRM was approved by a 6-0 vote, then having voted on the prevailing side, I would move that we reconsider the vote by which we approved the ADRM, so that I may interject this objection, but I'll do that at the appropriate time.
Okay. Well, we'll pick this up at the next time, and in the meantime, we can discuss the most, prudent way to proceed and to ensure that we can wrap this up in a way that's satisfactory to the procedural concerns that we have here, as well as the substantive concerns. So, before we wrap up, since this last item actually involved an entity from the state of Utah, I just want to take a point of personal privilege and just mention that 31 years ago, this month actually, I was a sophomore at Springville High School in Springville, Utah, and we won our very first state football championship of all time. And it may surprise some of you to know I was not actually on that team. I otherwise look like I might have the build of a middle linebacker, but no, basketball was more my sport. And I just want to mention that tomorrow, The Mighty Red Devils of Springville, Utah will be taking on East High School in the 4A state championship in Utah. It will be played at Rice-Eccles Stadium, the home of the University of Utah, and they'll be going for number 2. So I just want to send my best wishes to the Ripon Red Rage from Springville, Utah, and wish them all the best as they go for the state championship tomorrow.
Mr. Chair, where
Yes,
is
Commissioner Ravel.
Springville, Utah?
Springville is just near Provo, so about 15 minutes away from BYU. So, Commissioner Weintraub.
Well, I just want to say then that when I was at Bayside High School in Queens, I'm not going to say how many years ago, we were the city champs in football, and I also was not on the football team.
Fantastic. Yeah, it
Oh,
was.
Mr. Chairman,
Yes.
that's my personal privilege.
Commissioner Goodman.
In 1982, this month, I was on the football team that lost in the state championship in the AAA division of the state of Virginia to the Hampton Crab. I was at GW Danville, and we lost to the Hampton Crabbers 15-9. And I believe there were 4 or 5 NFL football players on that high school football team.
Okay. Well, there was one. My high school was led by future NFL quarterback Scott Mitchell. So he led us to our that moment of glory. So I guess I both unearthed pleasant and bitter memories. But I, like I said, I wish them all the best tomorrow. Hope they can bring home the state championship. Mr. Palmer, do we have any management or administrative matters?
What football team were you on?
I think it'd be hockey.
Mr. Chairman, I won't say the year, but my high school won the city championship in hockey, and I was on the team.
All right.
And I'm happy to report I amazingly have all my teeth as well. Mr. Chairman, there are no additional matters.
All right. Hearing none, this meeting is adjourned. Well, we'll keep